law keeping up? Are the tools available to victims of fraud and economic crime keeping up such that they have a chance to recover their assets, or is the law falling behind? And so that's the main question I hope that we'll have. I don't know whether everybody have an answer to it, and to lead off, I don't have the perfect answer to that question either, but I think it's an important one we ask and think about. And again, to lead a little bit into what the answer to that is, the Ontario Court of Appeal recently, judge of our court, so the highest court in Ontario, was concerned that the common law in our jurisdiction is struggling to keep up. So with that and that question, and keep in mind jurisdictions and changes in technology, I'd be interested in your comments at the end. Is the law keeping up? Now, and in particular, the last time I spoke to at this for this organization in Calgary in person, one of the questions were, which I'll try and answer now, how do you become a fraud and asset recovery lawyer? Like, why are you a lawyer focused on economic crime, and how did that ever happen? And so, as a first-year lawyer, I worked in a firm that dealt with insurance coverage issues. So I'm an insurance coverage lawyer. And the insurance clients in our jurisdiction were the biggest dealing with fidelity insurance. Now, fidelity insurance is employee theft insurance. So large corporations, not just in Canada, but around the world, are covered and typically have extensive coverage and complicated coverage for employee theft. And so I acted for a number of those companies as a young lawyer and on coverage issues. And then when the insurance companies paid to their corporate insureds, the insurance company then would be subrogated to that insured, their client. And what we started to do in a rather straightforward way was go after the employees that had stolen from their employer. And so at the beginning of my practice a number of years ago, that's how I started getting into economic crime, fraud, and asset recovery. I was doing that in Ontario and more generally across Canada. Now, interestingly, obviously I wasn't alone. This goes to my point about jurisdictions. At around the same time, we talk about the 80s, 90s, and early 2000s, many other lawyers in many other jurisdictions, as it turns out, independently started turning to asset recovery, fraud recovery, which had been, in my view, a neglected area of the law for years. And so if you have numbers of lawyers around the world in different jurisdictions dealing with asset recovery arising from fraud, what becomes apparent, as I started out, many of the frauds that we dealt with were relatively straightforward, kickback schemes, other corruption type schemes, outright theft, bookkeeping fraud. So fairly vanilla, what we would consider today, and fairly one jurisdiction focused, in my experience, Ontario. But I think that that would be a common experience for many other lawyers around the world. And so that's why I asked you to think about jurisdictions. So when I started out, it was pretty single jurisdiction and relatively straightforward frauds. Well, fast forward 30 years to today, and as Ryan pointed out in his generous introduction, I co-founded a group called the International Academy of Financial Crime Litigators. Now, I did that with two other co-founders because there was a real need or desire in the marketplace for this internationalization, this idea to learn from each other, because fraud, which probably always was the case 30 years ago, but today is clearly borderless and international in nature. Thereby, we have this International Academy of Financial Crime Litigators. There are lawyers from our jurisdictions all over the world, and we learn from each other and help each other in cases. So work on teams internationally to help clients recover assets and deal with other issues with respect to economic crime. So when I asked you to think about jurisdictions, really what I'm saying is, in fact, fraud today is now jurisdictionless in some respects, or borderless, except from the perspective of recovery, you have to acknowledge and understand what happens and how the jurisdictions are different and what the borders mean to your recovery. And you also have to understand that people defrauding or committing crimes, in fact, are often engaged in what I'd call jurisdictional arbitrage. Which is the best jurisdiction to carry out the fraud or the scheme, they would think and consider. Which is the best jurisdiction to launder the proceeds from the scheme in, might be a different jurisdiction. Which is the best jurisdiction to place value or hide assets once they've been laundered, could be yet another jurisdiction. And who will hold the assets for us or in what vehicles? What jurisdictions are the best place to incorporate? Which jurisdictions are more opaque with respect to ownership in jurisdictions? My jurisdiction is getting less opaque, but has historically been quite opaque. Do we set up trusts? Is offshore? Which offshore is appropriate? So if each one of you think you spend your days working at your job and working hard and diligently for your employer or your business, on the other side of it, there are just as many sophisticated and hardworking people doing the opposite from what we do every day, but is trying to facilitate economic crime. And I want to read just a paragraph to you that highlights this point. It's from British Columbia in Canada, a judge who had months of hearings with respect to money laundering in that province. And so I'm not reading to you with necessarily why it's relevant to British Columbia. In my view, it's relevant worldwide, and I think makes the point with respect to the sophistication and the jurisdictional arbitrage, which we all have to deal with in fraud cases. So Justice Cullen writes in his very lengthy report on money laundering in British Columbia, one paragraph at the introduction, he says, one thing, and he heard months of evidence from experts with respect to money laundering in that jurisdiction. One thing that has become apparent during the commission's process is that what many of those involved in profit-oriented criminal activity, so that's what we're dealing with here, profit-oriented criminal activity, crooks, stealing, he says, are rational actors who are aware of the different regulatory requirements in different jurisdictions and consider those differences in determining where to place and launder their ill-gotten gains. That's what I call the jurisdictional arbitrage. Faced with the prospect of having to prove the provenance of a particular asset, so in my example, a stolen asset or a laundered asset, to avoid a forfeiture order, those offenders, those are the people I call the smart, hardworking crooks out there, may choose to launder their proceeds and place their wealth in another jurisdiction. Again, to repeat, that's jurisdictional arbitrage. Where's the best place that I can get away with it? And this is something that we face, and many of you may face, when you're trying to deal with economic crime, is the point I raised at the beginning, what jurisdiction? Where is this going to happen? And so then from jurisdiction, let's move to litigation generally, and in particular, focus on fraud litigation or asset recovery or economic crime litigation. When I was a young lawyer, I litigated with the senior then Queen's Counsel, who would always say to me, he would say, Link, litigation is no tea party. And he was talking about commercial regular litigation. So if you think about commercial regular litigation, Pepsi versus Coke, the process will be started, litigation will start, documents will be exchanged, someone's going to win and lose at the end of the day, and someone will pay. Coke will be good for it or Pepsi will be good for it, and there'll be a determination and a judge will decide. Now, compare and contrast that with fraud litigation. If you've had, and your organization has lost a huge sum in a fraud scheme, are you going to confront the fraudster and hand him or her or the organization a statement of claim or otherwise start the process and say, aha, I've got you. I'm now suing you for all the money you've stolen from me, and look out, I'm going to get it all back. The courts have assisted victims in fraud in concluding, which I think probably many of you have already concluded, that fraudster, that bent organization, the one that's stolen the money, will not sit around and litigate with you, wait for a judgment, and then pay it at the end of the day. So the law has developed to assist victims of fraud. And for years, the premise was, before you got a judgment, so if you think Coke and Pepsi would litigate for years, at the end of the day, a judge is going to say one owes the other one money, it gets paid. In fraud litigation, a defendant would say, you don't have a judgment against me, my assets are mine, my information is mine, my records are mine, and you, plaintiff, victim of fraud, have no right to anything until you get a judgment. And what quite obviously typically would happen is that defendant, the crook, would have no assets at the end of any litigation and would not pay any judgment, which we would call as a paper judgment and worthless. So what did the law develop and when? This is where I want to start to take you through a little bit of the evolution. So what are these tools to assist victims of fraud? And I'll focus mostly on the common law jurisdictions. And I'm going to talk about just some of them. But I want you to think about the time these were developed, because that goes to my evolution and can the law keep up. At the time these tools that I'm going to take you through were developed, people watched something called television. And they probably sat around as a group at a certain period in the evening to wait for something called a sitcom to come on and watch it at the appointed hour with their TV dinners in front of them. Or there were still soap operas that people would wait for a particular time to watch together. And people wrote checks to each other. People used cash. And quite often, if you ever traveled on an airplane, you wore a suit. There weren't many people traveling. The world was still a pretty big place. And as I say, 30 years ago was very different than today. But that was the time when the tools that we still use today were first developed to fight fraud. And not surprisingly, those tools developed with respect to tying a ship up to a wharf, chicken feed, and bags of cash. Think about that. That's when the law started to develop these tools. And as you can imagine, contrast that with the world we live in today. And I talked about ships and wharves. Many of you are probably aware there's a case about freezing assets before you get judgment after a ship called the Morava. The whole point there, if you can believe it, was, well, wait a second, the plaintiff had a strong case to a right to a claim against the person who owned the assets held in the ship. The ship was about to set sail. The target or the defendant didn't have any other assets within the jurisdiction, which happened to be England and Wales. Therefore, the judge said, you have a strong case against the person who has the assets in the ship. The ship is about to sail. I'm going to make sure the ship doesn't leave the jurisdiction. There's no other assets here. We're dealing with pretty big assets and actually physically keeping a ship in a port. Now, that law has developed over the years. You can seek it without notice to freeze assets. There's a legal test to obtain it. You do it without notice. So is that back to my point? If you just sue a crook, the assets will disappear. This is to assist in making sure there are some assets there for when you do get judgment. So if you go to court without the defendants or the targets, you have to convince a judge that you have a strong prima facie case, and that test varies in different jurisdictions. You have to demonstrate there's a risk of dissipation. and you have to give an undertaking as to damages. If you're wrong, and this order has been issued, you, the plaintiff, have to pay the defendant damages. Now, the risk of dissipation can often be difficult to prove or to establish. And some courts in some jurisdictions have said, well, if you can show me that the defendant is actually a crook and has stolen from you, it's open to the court to infer that if you do serve that person or that entity with a statement of claim in the ordinary course, that any assets they have in the jurisdiction will be dissipated. Call them the jig is up cases, whereas if the defendant realizes that the fraud has been exposed, they will dissipate their assets. So I said earlier, that's all fine. You can do that without notice. There's a short fuse, and you do have to actually serve parties with the freeze order, and then they know that you're onto them in that jurisdiction. So interestingly, the issue here then is when and what do you do with respect to these freeze orders? Where do you seek one? So again, back to my point about jurisdictions. So easy if you in the first case, well, you got to go where the ship is. Pretty okay. Well, where's the ship? That's where we need to get a judge in that jurisdiction. Back to my theme. Well, from that time in the 1970s, fast forward to today, where are these assets? Which judge has the jurisdiction to make an order over, one, the person, or the person individually, to tell them they can't dissipate their assets, and two, to make an order against any third parties, mostly financial institutions, to not let the defendant take any assets out of the jurisdiction. So again, ships, that's pretty easy. If you're freezing a house, it can be expensive houses, but you know where to go. But if you get anything different, and I ask you to think about virtual assets, it becomes much more complicated. Who and what judge has the jurisdiction over those types of assets? Now, these freeze orders have developed to be worldwide freeze orders, and so you can get an order in our jurisdiction in Ontario over an individual, and it's over them personally, and our courts here and in many other common law jurisdictions will make an order against that person that has worldwide effect over that person. Now, to get that order, the effect of that order in any other jurisdiction against a bank or other properties, you have to go to those local jurisdictions to have it recognized. So again, think of jurisdictions, because once you do get a freeze order, say in Ontario, you have 10 days and you've got to serve it. Then the defendants know that you're onto them. And what if the assets are no longer in Ontario? And a freeze order in Ontario won't be that helpful. Even a worldwide freeze order may not be that helpful, because if the defendant has assets in other jurisdictions, he could either ignore the order, or other financial institutions that you aren't aware of yet, well, then he will just use them to dissipate the assets. And so if you think about it, how do you try to keep one step ahead of your defendant wrongdoer? So then something else, and this goes to the chicken feed. So we've gone from ships to chicken feed. And what does chicken feed have to do with fraud litigation? Well, in the first case, wasn't fraud litigation of the type that I'm talking about, but it was dealing with third-party discovery. How do you get information? So if you think in my example, well, I know that I've been stolen from, I know who did it, I don't know where the assets are, and maybe I don't know who else participated in it. So again, think of large multi-jurisdictional frauds. What other tool have the courts developed back when people used to watch television, as I said? And this is what's been called the Norwich Pharmacal Order, dealt with originally chicken feed and additives to chicken feed. So a plaintiff knew he had a claim because the product in the jurisdiction in which they had exclusive jurisdiction, this additive was getting in and being used. So they had a claim against somebody, but they didn't know who was bringing it into the jurisdiction. And what the court has said and this is to assist parties to make discovery of who the wrongdoer is. The court in the original case in the 1970s said, if through no fault of his own, a person gets mixed up in the tortious acts of others so as to facilitate their wrongdoing, he may incur no personal liability. So this is an innocent party carrying on their business, so no personal liability, but he comes under a duty to assist the person who has been wronged by giving him full information and disclosing the identity of the wrongdoers. Who's adding the additive to the chicken feed? Well, again, how does that help you in a fraud case? The common law expanded that to, ended up being called bankers' trust cases, so that what you can do is, instead of identify who the wrongdoer is you can now get an order against a financial institution. That financial institution disclose to you the bank records of the target defendant to assist you in tracing the assets. So you can see how this could merge together with if you've got a conundrum about freezing assets, but either you don't know where they are or you're not sure what you've got them all. A step to take, again, without notice to the wrongdoer and on notice to the financial institution, but with an order that the financial institution is unable to disclose to their client, wrongdoer, that they're going to release information to you. So a pretty good tool to get access to banking records and find out where did the money go. And again, something you want to do before you went and got a freeze order, ultimately the freeze order has that short fuse that I mentioned. And again, think about jurisdictions. Well, you can get the bank records and find out that there are no assets left in any banks in Ontario, for instance. They've all been transferred somewhere else. Well, then you know to go to that other jurisdiction and maybe do the same thing. Comes back to my original point, which as fraud becomes international, this idea around jurisdictional arbitrage is carried out by the wrongdoers, that fraud may be committed in your home jurisdiction where you are, but the assets may be in any number of other jurisdictions. So this is a tool to assist you in finding where the money is and then freezing it. But again, even the bankers' trust case, we're back when cash, checks, wires, and financial institutions were involved. Think about the world today. Still very different. And does and have we kept up chicken feed case keeping up with the world we're in with virtual assets? A third tool, similarly, from the same time when we were all sitting around watching television, a civil search warrant. Again, available to you civilly as a victim of fraud or in other cases, but here it's clearly an order you get from the court when you convince the court that there's evidence available that would demonstrate the fraud and or that there are assets out there. But the risk is that because the defendant is a crook, he has the assets, or sorry, he has the information or records or evidence that if put on notice, he or she will destroy the evidence. Again, here, think about the jurisdiction. It has to be served at a place, so a physical place where that evidence is, typically a business or somebody's house. Nowadays, it's more getting to a computer or a laptop or cell phones. But when it first came out, the records being sought in the first cases I was involved in were literally boxes and boxes of paper that you wanted to get that either had bank statements in it or had evidence that would demonstrate the fraud. Obviously, that's changed. We're now looking at laptops, phones, maybe some paper records. And so, again, the litigation has kept up, in my view, in that world, because we now can go in on notice. The defendant, if he has a laptop, has to turn it over, it gets mirrored, et cetera. Pretty quick turnaround, and you can get to and search the laptops and other computers to get the evidence. The issue there, of course, is that now the defendant is on notice that you're aware of the fraud and you're onto them. So again, when do you do that, and in what jurisdiction? So a good tool, and one that has moved along with the law and kept up in pace on the technology front. Now, I mentioned at the beginning multiple jurisdictions, or this jurisdictional arbitrage issue. So we've now talked about a couple of the tools available to us. I've tried to frame it in timing, when you take steps, and then in what jurisdiction. Now, I mentioned you don't want to immediately jump to taking steps to freeze assets in one jurisdiction without thinking about other jurisdictions and where other assets might be. And so you have to give very careful consideration as where you start any of this litigation. Back to my international lawyers around the world, you've got to consider, where do I start and what's the best jurisdiction? Some jurisdictions have advantages. Common law jurisdictions would have the tools that I've talked about. Civil law jurisdictions would have different tools available to you. And so at the front end, in assessing, when you're thinking about that we've got problems here, you can't just jump to any one jurisdiction. You've got to consider and step back, in my view, and decide which jurisdiction to start in, or multiple jurisdictions to start in. And think about, are there assets? Will we be freezing assets? Where are the records? Where is the information? And where are the people that perpetrated the fraud? And then you layer on top of that something that I won't spend a lot of time today on, but there are a lot of jurisdictions that have blocking statutes, so you can't get information out of them. Switzerland being an example. And so if there's records there, how best do you get those records out? You'll need local counsel to help you, and you have to orchestrate this whole plan around getting information first to prove your case, for instance. And then you also have to be very careful when you're litigating in international financial crime cases, is which case or which jurisdiction will be the prime jurisdiction. So it might be that the fraud was perpetrated in Ontario, and that may be the best jurisdiction as your prime jurisdiction. But in fact, no, the perpetrators are no longer within the jurisdiction of this court. They might be in a jurisdiction of a different court. Are you better to litigate in the court where the court has jurisdiction over them personally? And the analysis to determine that will have to be where they are, the laws of that jurisdiction, where the assets are, and where the records with respect to the information is. And so the point I want to make here is that rushing into economic crime litigation is not a good idea. Stepping back and thinking about it, in particular this jurisdiction arbitrage point, is important. Now, of course, in virtually every large fraud case, everyone's in a rush. You know, that's why we have freezing orders, disclosure orders, Int'l order. We have all this information to get in a rush. So one, the assets don't disappear. Two, the evidence doesn't get destroyed. And three, we find out where the money went, all front end loaded. And so everyone wants to do that in a big rush. Notwithstanding that, if you do it in the wrong jurisdictions, it may hurt you in the case later. So keep jurisdiction in mind. Now, I talked about when these tools started. So fast forward to today, if you've been in an airport recently, there are not a lot of people wearing suits. The world's changed. There are a lot of people in airports, a lot of people traveling. With today's communications, banking facilities, including on your phone, you can bank from anywhere. Now add in virtual assets, which you can control and transfer from anywhere. The world has become a very, very small place. So if you think back when these tools started, I talk about physically tying up a ship, or freezing a particular bank account in a jurisdiction. You think back to when I started employee theft, the employee was typically still in the jurisdiction, and you had one jurisdiction, one judge, one target, and bank accounts in that target, in that jurisdiction. With today's world, even those simple cases, more straightforward, with the prevalence of international banking, banking anywhere, virtual assets, there are no simple cases anymore. So back to my original question, has the law kept up? The world has become this small place in many ways, as this idea about ships, chicken feed, bags of cash, local searches, and Int'l orders, has that kept up? You know, what are you to do? What is a lawyer, fraud lawyer in today's world to do? And so I mentioned the Int'l in a way have caught up, in that you can now go to a target's house, satisfy the test, and get a laptop or a cell phone, have them mirrored very quickly. Through that process, have them searched for the relevant evidence and have it preserved. And even in the right case, get access to that evidence to find out where the money's gone. So that's positive, in my view. Of course, the downside is if you've only got one laptop and one phone in one location, the target can leave. If he has another laptop, another phone, or a co-conspirator with access to these things, then the phone is used to transfer the assets, and then you're now one step behind. So it has advanced in some degrees. But what do you do, in my example about the Norwich orders, which are typically quite an important part of this, these discovery orders, so you can get an order against the bank. You know, how have those moved forward, if at all? And what I'm going to read to you now is relevant to a rule change in England and Wales, and something I've been written about and suggested should be incorporated here in my jurisdiction. And so this deals with what I've told you about the Norwich Pharmacal or the discovery type order. And here, the master of the rolls is considering a change to the rules about service out for those type of orders to get information. And this is part of what the master of the rolls wrote. In the world of crypto fraud, there are no national barriers, and unlawfully obtained crypto assets can be difficult to trace. Well, there's an understatement, but an accurate one. And then the master of the rolls goes on to say, that is the experience of lawyers working in this field. I agree. Accordingly, the deputy head of civil justice and I have set up a subcommittee of the Civil Procedure Rule Committee to look at amending or expanding the grounds on which proceedings can be served out of the jurisdiction, in particular these Norwich or discovery orders. It is that obstacle that has impeded many sets of proceedings aimed at tracing the proceeds of crypto fraud. So here's an example, and a concrete one and a good one, where this rules committee, they're moving to change things. Now, of course, compared to wrongdoers out there and using crypto assets, we're lagging behind, obviously, and the law always does, but pretty forward moving in my view. And then if you go forward to my jurisdiction in Canada, our Supreme Court of Canada has relied on the fact and stated the internet has no borders to justify injunctive relief affecting foreign non-parties to litigation. And then so what I've argued for here is that if our highest court realizes that the internet is borderless, what the master of the rolls is doing in England and Wales, it's not a big jump to the crypto assets are borderless, which is what they're trying to deal with respect to this idea about service out. So, and why I'm pushing in Canada that there should be something similar or it should be considered here. Because if you think about the fraud litigation, it's all about trying to keep at least one step behind as opposed to 10 steps behind the wrongdoer. Historically, and certainly as the world became smaller, as I've set out, it became much easier for wrongdoers to get 10 steps ahead of you. And it became much more expensive, cumbersome, and slow to catch up. And so, in my view, the world has to change. The legal landscape has to change in some ways to facilitate keeping up with going after wrongdoers. Now, I started with money laundering, and so a different economic crime. The last 2 points I want to talk about are a little bit different than the asset recovery point, and then I'll turn it over to Ryan, who's got any questions. So, money laundering is a byproduct of the wrongdoing. Right? Money laundering is the wrong has occurred. It's the wrongdoing has generated an asset, and then how do you launder that asset into the financial system so the wrongdoer can use it? You know, you don't steal stuff just to keep it in your basement. You steal stuff so that you can use it, probably to buy fancy yachts or whatever. But the purpose of stealing it is to use it or use the value of what you've stolen. And if you go back to the time, again, think about the points I made earlier at the beginning, jurisdiction and sophistication in the world we're in. That's what I mentioned at the beginning, bags of cash. I mean, when you showed up at a bank with a hockey bag, because I'm from Canada, we'll talk hockey bags, or other bags of cash, there was a time when there was nothing wrong with the bank accepting the cash and depositing it. In fact, years ago, I had a case against a young kid who knocked off ATMs, and he worked for the security company. He literally stole cash and literally had hockey bags of cash in his house. And back then, he actually ended up using the cash to purchase a house, put a down payment on a house, and he was living off the cash he'd been stealing and literally keeping in hockey bags in his house. Today, the way the money laundering regimes have gone forward, there's no doubt he would not be able to do that. But today, the money laundering has gotten much more sophisticated. Typically, you're not stealing cash, like my example from the guy stealing from the ATMs years ago. The value that's being stolen, not even checks. Think of the old days when people would write checks and be forged checks. Nowadays, you know, it's all electronic, and layer onto that or virtual assets. So the idea of laundering the value into something to be able to use it to your own benefit as the crook has become so much more sophisticated. And if you look back at the money laundering regulations, which were minimal in the 80s, 70s, 80s, and have gradually gotten much more strict, you know, are they even keeping up with the situation we now face? The sophistication, the world being such a small place, money moving so quickly, and virtual assets. And then the last point I'll make is think about economic sanctions. We're in a world with the Ukraine war, Russia's invasion, and this idea around economics being used as a tool by the West to combat that war. And think about how that, in my view, ties into this world, the small world we have, the access to assets, the free-flowing assets, and the sanctions regimes in the different jurisdictions. And I'll leave that, at that point, I'll leave it as this question that I've asked: are we keeping up? And as I said at the beginning, a justice of our Ontario Court of Appeal said, in our jurisdiction, the courts are struggling. And you can't be too critical, because the way I've tried to put this together is, and what Justice Collins said at the beginning, these are sophisticated, rational actors working very hard to steal money every day. As I say, they're usually well-advised, profitable, and good at laundering their money. Now, am I completely pessimistic? No. The fight has to continue for my clients and yours, and that, in my view, the courts are getting better and are moving. They're conservative, so it'll be slower than we'd all like, but it's a positive step in the direction, and the two I've mentioned to you. So I think, Ryan, I'm just around the time when I'm supposed to hand it over to questions. Thank you very much. I hope that you've enjoyed that and that you found it interesting and entertaining.
Thank you so much for that, Lincoln. We do have a couple of questions. So I'm going to ask those. If anyone else has questions, though, feel free to use that Q&A button on the bottom of your screen there. It's just to the left of the chat button to post your questions in the Q&A box, and I can ask them for you. So the first question is, in a case of extradition, can the accused X sue the state L if the court X nullifies the case because the evidence is not strong enough to prove a crime?
Suing for damages, I guess, for the extradition, no, not that I'm aware of. So I understand the question, and I'm no extradition expert. But the question here is, the underlying crime is the government's not able to prove it, notwithstanding they either extradited the person or wanted to extradite the person. The case falls apart. The criminal case falls apart. I'm not aware of any basis for a civil claim against the government for failing to prove the criminal case and or pushing the extradition.
Perfect, thank you. The next question is, are you able to give us the link to the website of the litigator groups that you mentioned at the beginning of the presentation? Do you have those offhand?
Yes. I could pull it up probably. It's, yeah, if you ask me another question, I'll see if I can get that.
Not a problem. We can always type that in after or send it directly to the person after the presentation ends. The final question we have is, do you think financial crime is more likely increasing because of fiscal policies or economic and social welfare of people in a country?
Read that to me again.
Absolutely. Do you think financial crime is more likely increasing because of fiscal policies or economic and social welfare of people in a country?
Well, in today's world, the positive thing is everyone's been lifted up because of economic and social policies in many jurisdictions, which has given more people access to finances, to phones, and unfortunately, when you put all that into wealth, when you put all that together, what we are seeing, well, I'll call them consumer frauds, is that more people with wealth and access to spending their wealth, phone, internet, et cetera, have been targeted. And so to the extent, I'm not sure this really answers the question, but to the extent that the policies have raised people up, so you now have this more sophisticated group of citizens or consumers, the group I talk about, the ones that work all day to try and defraud people, have gotten onto that. And so now you hear about, the tax, the IRS in the US, IRS fraud, the CRA fraud here, you get an email, please send money for whatever reason. You have a larger number of people with the ability to respond and say, oh yes, I'll send you money over my phone, email you the transfer, et cetera. And less sophisticated people, especially elderly people, with access to these things that are victims of fraud. So the fraud has been, the smaller amounts are being taken from more and more people, which would be more difficult to do in the past. So both the sophistication of the electronic transfers and more people having access to that has, I think, increased those types of frauds.
Fantastic, thank you. We do have another question that popped up, and it is, do you think it is fair to treat crypto as facilitating financial crimes?
Crypto in itself is not criminal, obviously. The more success, if you go back to the internet, the web, the dark web, underlying technology behind crypto, they were all used for at their outset, especially the web and technologies, porn, money laundering, guns, drugs, extortion. You go through the list. The new technologies were all first jumped on by wrongdoers. And it seems like if your technology was really a good one, those types of wronged industries money laundering, porn, extortion, were all focused on it, sort of meant that you must be a new great technology because look at all these bad people are using it. Then, of course, the technology moves on and becomes mainstream and ideally pushes out the wrongdoers. And so if you think of crypto and parts of the web, yes, real focus on what people would call as bad things, but that's because the technology was being used by these sophisticated wrongdoers. So the underlying technology for crypto or virtual assets is probably a great technology, can be used for many positive things, and will and is being used. However, yes, it is being used by wrongdoers, but that doesn't mean that crypto entirely, for instance, should be banned or shut down. I probably couldn't do that, but to me, it's is there any way to focus it on the good things that we can get from crypto, and we have to put up with the bad things, and the regulators are moving in on crypto, and we'll see how that goes. So it's not to me, it's not crypto is only used by criminals, so therefore it's bad. It is being used by criminals, and it is a difficult thing for people like me to trace and find, but that doesn't mean that it's all bad.
All right, thank you for that. We do have one final question. Do you know the approximate percentage of such crime being reported in your jurisdiction and as the world as a whole?
Well, no is the answer, but there are a couple of accounting firms that come out with annual reports on international fraud to try and estimate that. So the person asking the question could try and look at that. The Big Four, I think, each have their own reports that estimate that. The Cullen Commission in British Columbia, so one province of Canada, estimated it was billions of dollars a year just being laundered through certain businesses in Vancouver. And so it's a huge, no matter, and I don't have all the numbers in those reports but it is a huge, huge number for money laundering and for fraud that people can only estimate. And so, I don't think it's not going to go away, in my mind. The best thing to do is be proactive about trying to go after it for your organization or your clients, because it always has been with us and always will be. And the point I was trying to make is, as the world gets more sophisticated and smaller, we'll see more of it in volume, in dollar volume, and it might be more difficult for people to get their money back. That doesn't mean we should give up.
Awesome. Thank you very much for that. That was our final question. So before we go, I want to thank you, Lincoln, for all the insightful and informative information during your presentation. It was obviously a pleasure having you join us again today. And thank you to everyone who attended today's Western Canada chapter webinar from around the world. Before you go, we would like to ask that you take a few minutes to complete a survey. You'll be prompted once you leave the webinar. The information collected will help us in our planning of upcoming events and ensure that the topics of future presentations and locations of in-person events meet the needs and interests of those who participate. For more information on the Association of Financial Crime Specialists organization and information on membership and invaluable training opportunities, including the CFCS certification, please visit www.acfcs.org. For information on the Western Canada chapter and our events, please visit our LinkedIn page and follow us. And thank you very much again.